All right, let's dive into one of the most powerful and honestly personal forms of evidence you'll ever find in the legal system, your very own words. So let me ask you this. Could the most compelling case against you be built just from things you've said or done? It sounds pretty dramatic, I know, but as we're about to see, the law often answers that with a pretty loud yes. Now, in legal speak, this is what's known as an informal admission. And don't get hung up on the word formal. We're not talking about a signed confession at a police station. No, this is way broader. It's basically any statement or any action that ends up hurting your own case. And that's a really important distinction to make. See, a formal admission, one you make in court documents, is legally binding. It's pretty much set in stone. But an informal admission, the kind we're talking about today, well, that's different. It can be explained, it can be contradicted. At the end of the day, it's really up to the court to decide just how much weight it carries. So, here's our game plan. We'll start with admissions made by words, and then we'll move on to admissions by conduct. After that, we're going to get into the nitty-gritty, the fine print, and the rules, before we wrap it all up with why this stuff matters so much. First up, admissions by words. Now, this is the most straightforward category, but you might be surprised by just how wide the net is cast here. This quote from an old case really says it all, doesn't it? A comment you make to your spouse, something you mutter under your breath to yourself, if someone overhears it and it's against your interest, boom, it can be used as evidence. The context almost doesn't matter. And this is where the rule gets seriously powerful. Okay, so normally there's this thing called the best evidence rule, which says that to prove what's in a document, you need the actual document. Makes sense, right? Well, an admission is a huge exception. If you admit out loud what was in a contract you signed, that statement can be used as proof, even if the contract itself is never seen in court. But hey, it's not just about what you say. The law is also paying very close attention to what you do. And that brings us to our next topic, the silent witness, or admissions by conduct. This whole idea boils down to a concept they call consciousness of guilt. It's pretty simple, really. The theory is that certain actions strongly suggest a person believes they're guilty, even if they never, ever say it out loud. And the examples are probably exactly what you're thinking of right now. Running from the scene of an accident, shredding a document, or making up an alibi that completely falls apart. Even something like giving a fake name to a police officer. Each one of those actions tells a story, and that story suggests a real fear of the truth coming out. But it's not a total free-for-all. There are some really important rules that control how admissions can be used, and they're all about fairness. So let's take a look at the fine print. Okay, first and foremost is this critical rule about fairness. Let's say you make a statement that's got both bad parts and good parts, what's called a mixed statement. The other side can't just cherry-pick the incriminating bits and completely ignore the parts that help you. The principle is that the whole statement, with all its connected pieces, has to be considered together. This makes sure that the court gets the full context, including any explanations or justifications you gave right then and there. So, for example, imagine someone says, "Yeah, I took the money, but I was going to return it tomorrow." The first part, "I took the money," is damaging. That's inculpatory. The second part, "but I was going to return it," is the explanation. That's exculpatory. A jury has to hear both parts. Now, they might believe the admission but not the explanation, or they could believe the whole story. The point is, they get the entire picture to decide. All right, here's an interesting one. What if you admit to something you don't actually know firsthand? Like, if you state your age, you don't remember being born, right? You're going off what you've been told. Does an admission like that still count? Well, the answer is a little bit complicated. An admission doesn't absolutely require personal knowledge. It can be based on your belief. But its value as evidence gets weaker and weaker the less you actually know about it. As one judge famously put it, if a man admits something of which he knows nothing, it is of no real evidential value. So while it might get admitted into court, it might not be very persuasive. So let's bring this all home. Why does the law put so much stock in all of this? What's the big takeaway when it comes to admissions? It really all comes down to this one simple, powerful idea. There's a common sense assumption that, people don't usually admit to things that are bad for them unless those things are actually true. It's seen as being naturally reliable. And that very idea of reliability gives admissions incredible weight in court. So much weight, in fact, that sometimes an admission can be the only piece of evidence needed for a judge or jury to decide an entire case. That's true for a small civil claim, and it can even be true for a criminal conviction. It's that powerful. And that leaves us with one final thought to chew on. We've seen how statements, whispers, actions, even lies can all be collected and presented as evidence. It really makes you think, if everything we say and do can tell a story in a courtroom, what story are you telling every single day?